Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 500 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Battery lawyer in Illinois. If you've been charged with battery in Southern Illinois, you could be facing steep penalties, including decades in prison. The seasoned Southern Illinois criminal defense lawyers at Combs Waterkotte have over 60 years of combined experience safeguarding the futures of people just like you. Take a closer look at what battery charges involve in the Prairie State and what we can do to fight for your rights and freedom. What is battery in Southern Illinois? Battery is one of the oldest violent crimes covered by U.S. laws. In American common law, battery occurred when one party intentionally touched someone else in a harmful or offensive way. The common law defined assault as deliberately causing someone to fear an imminent battery. Thus, a battery required contact, while an assault did not. States took two approaches as they codified their criminal laws. Some states, like Missouri, combined assault and battery. Other states retained the distinction between assault and battery. In Illinois, for example, battery and assault are different charges with different statutory requirements and punishments. Possible defenses against battery charges in Southern Illinois. The strategies we can use to defend you depend on the unique facts surrounding your case. However, some general criminal defense strategies that may apply to your case include self-defense and defense of others. Illinois law allows you to use force to defend yourself or others under the self-defense statute. Self-defense applies when you use the reasonable level of force necessary to stop another person's imminent use of unlawful force against you or someone else. When successful, self-defense is a justification that can result in a dismissal or acquittal of your charges. That's because this defense allows for a reasonable mistake. For example, if someone lunges at you with a knife, you are allowed to defend yourself even if the other person only meant to scare you and did not intend to stab you. On the other hand, this defense is limited. If you were the initial aggressor, you typically cannot use self-defense as a justification unless the other person escalated the fight or you withdrew and the other person kept coming at you. In these situations, you may be legally allowed to defend yourself. Defense of your dwelling. You may also be permitted to use force to defend your dwelling. Dwellings include homes, but they can also include cars, tents, or RVs that you live in. Again, you can use a reasonable level of force to prevent the other person from attacking or unlawfully entering the dwelling. Privilege. The Illinois statutes exempt some uses of force from battery. For example, police officers can use reasonable force to execute an arrest. Similarly, a merchant can use reasonable force to detain shoplifters. Lack of intent. The battery statutes require knowledge and intent. This means prosecutors must prove that your actions were willful and that you were aware of the circumstances that made the act criminal. Thus, you can raise a lack of intent if you touch the victim due to an outside force, such as being pushed into them. However, you cannot argue that you lacked intent because you didn't know the law. If your actions were intentional, you may have violated the law even if you were not aware of the battery statute. Battery defenses often depend heavily on witness testimony. Even the smallest detail might make the difference between an acquittal for self-defense and a conviction. That is why we discuss an incident thoroughly with a client before investigating the alleged victims and interviewing eyewitnesses to get the full story. Our team can then present our findings to the prosecution. We can negotiate for a dismissal or plea offer that helps you reduce your possible punishment. If the prosecutors refuse to offer a fair plea deal, we can fight your charges in court, presenting your defenses to a jury and advocating for an acquittal.